Madeleine, taking stock of the changes to contact and residence orders, has the name child arrangements made any difference?
I think it's made some, because we all know as practitioners and judges that the intention behind the changes was to avoid the sort of arguing about control that comes with whether it's a residence order or whether it's a contact order, and the primary parent and the secondary parent. And I think it's very clear to everybody working in the system that those sort of ideas need to be pushed to one side, and we need to refocus on welfare. The difficulty I think there has been is that when all of the drafting amendments went through, of course, a whole number of other statutes refer to residence orders in particular, because having the status of a residence order would bring with it all kinds of consequences in terms of what you could and couldn't do, and your rights, and how you were treated by the local authority, and whether you could travel, and all those sorts of things. And what happened when the drafting was done was that all of those residence orders got translated into child arrangements orders that provide for where the child is to live. So it really is, in those contexts, a residence order by another name. But what that means, of course, is that lawyers have to advise their clients that there are some consequences to whether your child arrangements order says lives with or not. So in a way, we're back in the position that we used to be in, because if your lawyer thinks there's a difference, then the parent will think there's a difference, and you end up arguing about it all over again. So I think some of the desired effect has been achieved, but we still have those niggling problems. We're not completely in an area where we can just say we'll settle the arrangements with the child, and it doesn't matter whether you're a lives with parent or a contact parent or anything else parent.